Chairman. Mr. Chairman, writing the majority opinion in Shelby County, Chief Justice Roberts wrote that the Voting Rights Act employed extraordinary measures to address an extraordinary problem of pervasive discrimination in suppressing the right to vote. The Chief Justice pointed out that in 1965, Section 4's preclearance formula was the kind of strong medicine needed to address racial discrimination in voting, an insidious and pervasive evil which had been perpetuated in defiance of the Constitution. Today we begin the task of updating the preclearance formula to reflect today's America, and I thank the Chairman and the Ranking Member for holding this hearing. In the 60s, we could rely on overtly racist laws to trigger preclearance in the Voting Rights Act. For example, the use of literacy tests to establish if, quote, someone has the moral character worthy of the right to vote. These are the laws that John Lewis and so many other brave Americans fought to dismantle. And it's an honor to have you here today, Mr. Lewis. And while there may be fewer overtly racist laws on our books today, when pundits and commentators and TV hosts say that racism is behind us, we're avoiding an important discussion that's got to take place. And I frankly think that this is a good place for it to start. Racism is still here in this country. It just takes a different form. Jim Crow, I would suggest, has been replaced with a far more subversive and far-reaching system of institutionalized racism. So as this Congress works on a new preclearance formula, I humbly suggest that we look beyond the scope of laws passed by states that directly impact minorities at the polls and begin looking at the racially biased application of state laws more generally. For how healthy is the democratic process in any state if we see institutional racism enshrined in our laws or the application of those laws that limit minority access to the polls as well as their basic equal protection under the law? Laws that too often prevent minority communities from having a true and full voice in local, state, and federal elections. 3 examples. There's been much discussion about stand your ground laws in connection with the recently concluded Zimmerman trial. There are 23 states with self-defense laws in which there is no duty for a person to retreat from an attacker. 9 of these states, including my state of Florida, permit a person to stand your ground and use lethal force when being attacked. Unfortunately, studies show that stand your ground laws mainly protect white people who shoot a black person. How healthy is our democracy when, according to an Urban Institute analysis of FBI data, white people who kill black people in stand your ground states are 354% more likely to be cleared of murder charges? Couldn't one argue that stand your ground laws and the use of such laws reflect modern racial bias in state laws and should be considered here in this context as we modernize our preclearance for Voting Rights Act? Second example, we see institutional racism in the application of our drug laws. Blacks and whites may use marijuana at similar rates, but black Americans are nearly 4 times more likely to be arrested than whites, according to the ACLU. The state and local governments have aggressively enforced marijuana laws selectively against minority communities, placing hundreds of thousands of people into the criminal justice system. Shouldn't we ensure that states who throw young black Americans in jail at a disproportionately higher rate than white Americans for the same offense are also not passing laws to further disenfranchise minority voters? And the third example is this, and it is more pertinent and specific to this discussion. We see institutional racism in the flood of new voter ID laws. Studies show that as many as 11% of eligible voters do not have government-issued photo IDs. Why do many minority voters lack IDs? Often they don't need them. Minorities are less likely to have a driver's license because they're more likely to live in urban areas and often more likely to be poor. Shouldn't we recognize that voter ID laws seek to disenfranchise certain eligible voters, not blatantly based on race, but based on requirements that have significantly and intentionally racial ramifications? Isn't that evidence of institutionalized racism, and shouldn't that merit extra federal scrutiny and preclearance in those states that have passed those laws? Racism has grown more insidious, subversive, and more subtle in the 50 years since the Voting Rights Act, but it's not gone away. We have too much yet to do. It's no wonder why African Americans in Florida and across America so often feel like their voices, if not their lives, are being devalued by our laws. It may be harder for us to pinpoint racism, but that doesn't mean that it's been abolished. And that we in the United States Congress have a constitutional duty to ensure that we are doing everything in our power to protect every voter. So, as we go through this process, shouldn't we be brave enough to acknowledge that if any state law reflects institutional racism, that preclearance of laws affecting the right to vote in those states should be required? And shouldn't the concept of voter suppression be broadened to include the more subversive, the frankly much more sophisticated ways that institutionalized racism has reared its head? These are difficult questions. We're not going to have time to discuss them here today, but I hope as we go forward with this discussion of the Voting Rights Act, we're willing to have the brave conversation that I think will help us immensely here on this committee and ultimately will serve our country well. I yield back.
And I thank all of the participants